Good. Hello. I'm going to kick things off. Hello and welcome to the Rafa Learning Community. My name is Dennis Gogarty, and I'm the president and founder of Rafa Investment Advisors. Thank you very much for joining us today for DEI initiatives in the crosshairs of the administration, what nonprofits need to do to mitigate your risk. For those of you that are new to our community, Rafa is an investment advisor firm created specifically to manage reserves and retirement plans for nonprofits and associations. We're celebrating our 20th anniversary this year. We were founded in 2005 as an affiliate to a large public accounting firm. And as of December 31st, we are advising on approximately $2 billion in assets, including more than 150 nonprofit clients. Our values are excellence, education, and well-being, and the Rafa Learning Community is our effort to provide nonprofit leaders with high-quality, actionable education content on all aspects of running a successful organization. Before I introduce today's presenters, some quick housekeeping. If you have questions, please enter them into the Q&A box, not into the chat. You can ask your questions, pose those questions into the Q&A box throughout the presentation. If those questions are not addressed during the presentation, we will address them, or Kevin and Jeff will address them at the end of the presentation. So we'll leave plenty of time for those questions at the end. Also, we're a CAE registered provider. Today's session has been approved for 1 CAE credit. And so if you have any questions about that, don't hesitate to reach out directly to us. And now I'm delighted to introduce our presenters for today's session, Jeffrey Tenenbaum and Kevin Serafino from the Tenenbaum Law Group. First, Jeffrey is widely regarded as one of the nation's leading nonprofit attorneys and is also an accomplished author, lecturer, commentator, and expert witness on nonprofit legal matters. As managing partner of the nationally recognized Washington, D.C.-based Tenenbaum Law Group, a 6-attorney boutique law firm focused exclusively on the needs of nonprofits, Jeff counsels his clients on the broad array of legal and sensitive business and governance issues affecting nonprofits. Among numerous other honors and awards, Jeff is the recipient of Association Trends and CEO Updates 2025 Association Industry Partner of the Year Award. He was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award, has been one of only a handful of leading lawyers in the prestigious U.S. Legal 500 non-for-profit rankings over the years, and is one of only 5 lawyers in the U.S. Legal 500's non-for-profit Hall of Fame. Every year for well over a decade, Jeff has been listed in the nonprofit categories of Best Lawyers and Super Lawyers. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, which is only slightly more popular than his second and much more interesting book, Quarantine Cocktails. So look out for that. He currently serves as chair of the American Bar Association's Trade and Professional Associations Subcommittee and on several ASAE committees. Thank you, Jeff. And Kevin, thank you also for joining us. Kevin is an associate at Tenenbaum Law Group PLLC, where he advises nonprofit organizations on a broad range of legal issues. He counsels public charities, private foundations, trade and professional associations, and social welfare organizations on formation, federal tax exemption, governance, and major transactions. He also focuses on advising politically active organizations on federal and state lobbying, ethics, and campaign finance law, and assists in designing compliance programs to complement high-impact advocacy work by nonprofits. Prior to practicing law, Kevin spent more than a decade in lobbying and compliance roles for 2 national trade associations, where he lobbied U.S. Congress and federal agencies and managed political strategies and fundraising. He holds a Certified Association Executive certification from the American Society of Association Executives and has been honored as a fellow by the Bryce Harlow Foundation, an organization dedicated to advancing the integrity of government advocacy. So Kevin and Jeff, thank you again for joining us today. Please take it away.
Thanks, Dennis, and thanks everyone for joining us today. We have a lot to cover in the next 55, 53 minutes or so. We're going to do our best to do that and also to leave plenty of time to answer your questions. And if past is prologue, Dennis, if you can put yourself on mute, that'll stop that from popping up. Um, if past is prologue, you're going to have a lot of questions today. This is the fourth webinar that we've done on this topic in I think about 10 days. This is a very hot topic right now in the nonprofit and association communities. This is an area of great potential legal risk for certain organizations and a lot of risk beyond the legal side that we're going to talk about here today. That's equally important to take into account. So what we're going to do here today is we're going to start with a discussion of the new Trump administration's executive orders relating to DEI, diversity, equity, and inclusion. And we're going to explain what those mean, how they apply potentially to associations and nonprofit organizations, both those that receive federal funds, federal awards like grants, cooperative agreements, and contracts, and those that don't. And that's a very important distinction because without question, right now at the present time, the biggest risk area in this whole realm of issues that we're going to be talking about here today um, comes from um, comes from organizations that receive federal funds. And for instance, in the association community, while many association members receive federal funds, I'd say the majority of most national trade and professional associations, in our experience, do not receive federal funds. But that does not mean that they are without risk in these areas, and we'll talk about that. Those that do receive federal funds have a much higher level of risk, and we'll talk about what that means and what sort of steps you might want to take to help mitigate that risk. We're also going to talk about a legal development that happened almost 2 years ago, the 2023 U.S. Supreme Court decision involving two colleges and universities and their affirmative action programs dealing with race in the college admissions process. A decision that Kevin will explain that adopted essentially a reverse discrimination line of reasoning that now disallows the consideration of race as a favorable factor in the college admissions process. What has happened in the last 2 years since then is that there has been a lot of fallout from that decision, even though that decision in and of itself is limited to colleges and universities and the admissions process. The line of legal reasoning and thinking behind it has extended well beyond the college and university setting. It has spurred a number of lawsuits, including by the same individual who brought those cases. And that has very significant potential impact on all nonprofit organizations and associations. And it has nothing to do with the receipt of federal funds. And what we're seeing is that the new administration's really strong and high profile anti-DEI drive and initiatives and enforcement is spurring these things in the private litigation space at the state regulatory and legislative levels in ways that we have not seen in the last 2 years. And Kevin and I believe that that's actually going to have a lot of potential adverse impact on associations and nonprofits, including those that do not receive federal funds. And then we're going to talk about some other potential kind of fallouts from these actions and what your nonprofit organizations can do to help to mitigate these risks. And always with an eye for everything that we try to do through our articles and speaking presentations, we want to focus on practical tips, suggestions, guidance, things that you can do now to help to mitigate your legal and other risks in these areas. I do want to highlight an article that Kevin and I wrote. Maybe if someone, or actually in a second when Kevin takes over, I'll put it into the chat. An article that we wrote on the topic that is on our firm's website. If you go to tenenbaumlegal.com, tenenbaumlegal.com, and click on the publications tab, you'll see that article. We just wrote it a couple weeks ago, and I think it gives a pretty comprehensive overview of these issues, and I'm sure we will be writing more in the coming weeks and months. So with that, I'm going to turn it over to Kevin to get us started. And then I will come back and talk about a few other issues, and then we'll open it up for your questions. Kevin?
Thanks a lot, Jeff, and good afternoon, everyone. I'm going to kind of get kicked off here by describing some of the legal background that most associations and nonprofits are subject to right now. Some of the executive orders that we saw in the early days of the administration, as well as a couple important evolutions of those executive orders. And then, like Jeff said, backing up a little bit into the 2023 affirmative action decisions that, with that reverse discrimination line of reasoning that is really forming the anchor for our legal analysis for most of our clients on these issues today. So just getting back into the time machine for a minute, going back to January 20th, the first day of the second Trump administration, immediately after being sworn in on January 20th, one of the first executive orders that the president issued was directed at environmental justice programs broadly. It directed the federal government to terminate all discriminatory programs, including DEI, under whatever name they may appear. So it's using the terms diversity, equity, inclusion, but also expanding it broader than that. Specifically, it got into contractors who were providing DEI under environmental justice programs administered under the Biden administration. So that was the very specific environmental justice focus of an executive order, but it also broadened to include a lot of DEI initiatives that were connected to environmental justice. The very next day, on January 21st, we had an additional executive order that overlapped significantly with the one from the day before, but focused more specifically on DEI programs without the environmental justice lens. And it made a very broad policy statement declaring that DEI programs were discriminatory and illegal preferences. And it revoked executive orders that had addressed non-discrimination for decades, dating back to ones signed by President Lyndon Johnson after the Civil Rights Act. And it directed federal grant recipients to certify their compliance with this executive order and to certify that they do not engage in any illegal DEI activity. Where it scared a lot of nonprofit organizations is its reference to private sector enforcement. It directed the federal government to develop lists of organizations for enforcement. It cited Fortune 500 companies, colleges and universities, and large nonprofit organizations, bar and medical associations. So those were some of the provisions that really spooked a lot of folks in the association world. But I think the overarching theme of these executive orders is a couple of things here. They were intended to sow fear. They were not very much based in law. They were more based in political rhetoric, and pretty inflammatory political rhetoric, calling DEI programs dangerous and demeaning and immoral. There are only a couple legal citations in these executive orders. One was the Civil Rights Act of 1964, and the other was the Students for Fair Admissions case, the affirmative action case from 2023. There was very little else in there, even though we know there is a significant body of law on both of those topics, discrimination in employment, in education, the whole body of the Civil Rights Act and everything that's come since. And none of that was really present in this blanket declaration of illegal DEI. But it's also important to note that, so far the administration doesn't seem to be bound by what's legal and what's not. They've, pushed forward with many of their plans. They've been challenged in court. They've been enjoined in many cases. But it seems to be a shoot now, ask questions later type approach from the administration. But that doesn't mean that we should accept their contention that all DEI is illegal. In fact, they stop a little bit short of declaring that every DEI program is illegal. In fact, they seem to want to ban what they call illegal DEI, which we don't exactly know how that's defined, which creates part of the problem for nonprofits who want to comply with these executive orders. But that's something to keep in mind, is that the executive orders enforce current law, but they themselves do not create any new law.
And Kevin,
So
let me just interject for a second. One undercurrent of all of this is the litigation that's going on to challenge basically every executive order and other actions that have been taken in this whole area, this whole arena, have been challenged in court multiple times. And some of the early court challenges are having some early success as well. And while the administration seems to be charging forward, and they knew the litigation challenges were going to come, they've been prepared for them. The proponents who were prosecuting the litigation were also very prepared coming into this administration. And we're going to have to wait and see how everything plays out. I mean, just today we saw the U.S. Supreme Court decline to intervene in a lower court's ruling that paused the administration's pause on foreign aid, things like that. And we're going to continue to see how these play out. But what we are seeing, like I saw it this week, the U.S. Department of Education had initially put out some guidance to all colleges and universities and K through 12 schools regarding DEI initiatives and basically threatening to cut funding for schools at both levels that were engaging in illegal anti-DEI initiatives. And I put that in air quotes because we don't know what that means. There was a lot of pushback apparently from some of the lawyers in the administration and the department. And then the department issued revised guidance that pulled a lot of that back and hewed generally to the contours of existing law in this area regarding what is illegal, what are illegal DEI initiatives and what is not, because there was so much concern that they were overreaching there. So we're just going to have to see how things play out, keep a close eye on it. But having said that, I do not think, and we're going to get to this a little bit later when we're giving our practical guidance and suggestions, irrespective of all of this, irrespective of the uncertainty, irrespective of the fact we don't know how these court challenges are going to go or how the administration is going to land on some of these issues. It doesn't mean you should do nothing right now. Not at all. There's a lot of things you can do. Kevin and I and our colleague Holly are in the midst of 15 or more different reviews for clients of ours, Association of Nonprofit Clients, on all of their DEI-related initiatives, analyzing them one by one and going through and giving our thoughts, our commentary, and our practical advice on things that they can do in each one of these areas, some more than others, to mitigate their risk. And that's an important theme I wanted to stress. Anyway, back to you, Kevin.
Thanks for that color, Jeff. I was actually about to get into kind of one of those pieces I think you made reference to, which was a recent court case enjoining some of the elements of these DEI executive orders. But before, that's one of the recent evolutions we've seen since those January executive orders. But right after she was sworn in as Attorney General of the U.S., I think it was on February 5th. Pam Bondi issued a pair of memoranda to U.S. Department of Justice personnel instructing them on how to carry out the president's executive orders. And it was, it used some similar rhetoric. It pointed to illegal DEI programs. It didn't contain too much more of substance on the law. But one element that it did include was that it said in a footnote that, recognitions of cultural contributions and general educational elements are permissible under the executive order. It referenced celebrations of Black History Month, for example, as something that is explicitly allowed, at least under this DOJ memo. So that offered at least a little bit of insight into how the lawyers might look to this and the vulnerabilities they see in these DEI executive orders issued by the administration. The second evolution that I wanted to highlight that Jeff alluded to a moment ago was just a couple weeks ago, a U.S. court, a federal court in Maryland issued an injunction against a few portions of these DEI executive orders on constitutional grounds. And without getting too much into civil procedure, getting a preliminary injunction requires at least some showing that you're likely to succeed on the merits of the case. So that's usually a pretty good indication as to how the judge is leaning. But it enjoined these provisions based on First Amendment free speech grounds, also under Fifth Amendment due process grounds, because saying that the executive orders were unconstitutionally vague, something that we discussed just a moment ago, that we don't know what these core terms really mean, and also some separation of powers claims. So that's something, a court decision to really be keeping an eye on. And it, like Jeff said, it was very obvious that the plaintiffs in that case were well prepared to make their constitutional claims in favor of continuing broad-based diversity, equity, and inclusion programs. So the last kind of legal background piece I wanted to share that we've alluded to a couple of times already is the affirmative action cases from 2023 that really established a strong precedent for this reverse discrimination line of legal reasoning. So as most of you probably heard, it was a case brought by an advocacy group against Harvard and the University of North Carolina, claiming that their use of race in college admissions was impermissible. The decision really, it disallowed the use of race in college admissions, but the hook that they used to get to these private organizations was that college and universities almost universally accept federal funds by accepting student loan proceeds and other things like that. So that was really the federal hook to have this apply. But the reasoning has started extending to other areas of the law. Specifically, most observers think it's going to extend to Title VII of the Civil Rights Act, which addresses discrimination in employment. That's one risk area that Jeff is going to talk about in a little bit. But also, we're seeing the reasoning start to infiltrate other areas of the law. It's cited as a Supreme Court precedent, and we think that it's going to form the anchor of the analysis for any DEI program across all different contexts, whether it's education, other benefits, scholarships, grants, things like that. So it's definitely a case that we recommend taking a look at if you haven't. But it's one that we think is going to be seminal to the reviews of these kinds of programs going forward. So Jeff is going to take it over from here and talk about some of the key risk areas that we see for associations and nonprofits in administering their DEI programs, things like you discussed, federal grant funding, contracts, employment, and the rapid evolution of state laws to go along with some of these federal executive orders and federal directives. So, Jeff, back over to you.
Thanks, Kevin. Okay, let's start with where Kevin just left off. The kind of reverse discrimination rationale of the 2023 U.S. Supreme Court decision. Basically saying if you are giving preference to certain racial minorities, for instance, in the college admissions process, and you're not giving that same preference to, say, white people, that you are discriminating against white people in that process. So once we saw that decision, we had no doubt that that line of reasoning was going to be expanded into other areas. One area is the employment area, and we have seen a ton of litigation since 2023, June of 2023, in the employment area. We're seeing cases continue to work their way through the courts. There was actually a case just heard by the U.S. Supreme Court last week involving reverse discrimination against a straight white woman who claimed that she was not promoted and then ultimately let go because she was not gay. In that case, apparently from what I read about it, there seemed to be a majority of the justices who seemed to be leaning in her direction on that case. And that's not surprising. And I think we're going to continue to see more and more of that. And I'm going to talk about the employment space in a second, which is a very significant area of potential liability risk. Something that was not at all directly impacted or even commented on by the administration's executive orders and other recent actions, but it's something you absolutely need to focus on. Every nonprofit, including those that don't receive federal funds. But another area that I don't think many people saw coming, I know I didn't, was something called Section 1981. You're probably wondering, what the hell is Section 1981? Well, Section 1981 is a provision of the original Civil Rights Act, not the Federal Civil Rights Act of 1964 that everyone knows about it, is well aware of, but the Civil Rights Act of 1866, which was enacted by Congress and signed into law after the end of the Civil War, after slavery ended. And one of the things that it did to try to protect the rights of slaves, former slaves, was to prohibit discrimination in contracting on the basis of race. Just on the basis of race, not any other protected characteristics. So it has been illegal since 1866 to discriminate in contracting on the basis of race. And the idea was that Congress and the administration wanted to make sure that the freed slaves were able to engage in business ventures, make a living by being able to enter into contracts, and not be discriminated against on the basis of their race. Now, for decades, well over a century since then, that provision, there has been litigation on that, but it's largely been used to help protect racial minorities from discrimination in contracting. But that was flipped on its head after the 2023 U.S. Supreme Court decision. And the same individual, Ed Blum, who formed a nonprofit to bring the higher ed cases, formed another nonprofit called the American Alliance for Equal Rights to bring cases against those organizations, entities, and businesses, including nonprofits, that they believe are engaging in reverse discrimination in contracting on the basis of race. And one of the notable cases, because it involved a nonprofit, is a case that was brought against the Fearless Fund, technically against Fearless Fund Management, LLC, which was a venture capital fund owned and run by Fearless Fund, which is a 501c3 nonprofit tax-exempt organization. And that case sued Fearless Fund Management, LLC, which was giving out, awarding $20,000 grants to Black women-owned and run businesses. And eligibility was limited to Black women-owned businesses. And Ed Blum's group, AAER, brought the case and alleged that this was discriminating against non-Black women-owned businesses on the basis of race. For instance, white women were not eligible for these grants. The lawsuit had some success and ultimately was settled by the parties in September of last year, and the Fearless Fund agreed to terminate its grant program. AAER also brought lawsuits in 2023 against two national law firms that had operated paid diversity fellowship programs for many years aimed at bolstering diversity and inclusion in their attorney ranks. Eligibility was limited for these fellowship programs based on certain protected characteristics, including race. Ed Blum's group brought the same sorts of litigation, 1981 violations on the same bases, and ultimately both law firms backed down and agreed to either abandon or change their eligibility criteria for those fellowship programs. Now, some of you might be asking, and some of our clients have been asking when we've been doing these analyses, I thought 1981 only had to do with contracting and discriminating in contracting on the basis of race. Well, the reality is that things like the $20,000 grants that Fearless Fund was giving out involved a contract. You couldn't get the grant without agreeing to a contract. Fellowships virtually always have some sort of terms and conditions that the fellowship recipients have to agree to. Same for scholarships, same for grants, same even arguably for things like board service, where most nonprofits have board members, incoming board members, sign some form of a form, an agreement that deals with things like conflicts of interest and confidentiality, sometimes a code of conduct, sometimes copyright assignment. And whether you think of it that way or not, those are contracts. And a contract can be written, it can be oral, it can be implied, but those are definitely contracts. Even things like speakers, for at least it's certainly a best practice for speakers in the nonprofit community, for association conferences and meetings and webinars and other nonprofits to enter into some sort of an agreement. It might be a click and accept form on online, but it's something where you are agreeing to those terms and conditions of being a speaker, usually things like a copyright license, agreeing not to do and say certain things, agreeing not to share any confidential information, to say anything defamatory, invade anyone's rights of privacy, things like that. Those are contracts as well. So to the extent that you have certain limited designated speaker slots only for people of certain protected characteristics, which some nonprofits have, to the extent you have board slots that are limited solely to people of certain underrepresented groups, certain minority groups, that is exactly what we're talking about. Certainly grants, scholarships, fellowships, things like that all involve contracts. And so if you have any exclusionary features in those programs where eligibility is limited to certain people, that whether it's based on skin color or other things, including race, and say like the straight white guy is not eligible for those programs, you run the risk of a Section 1981 violation. And these rights can be enforced by an aggrieved individual who didn't get one of those scholarships, grants, fellowships, etc., can be brought by a group like AAER, who will find some of those white folks who didn't get the scholarships or grants and bring those as named plaintiffs in the suits. And theoretically, it can be enforced by the U.S. Department of Justice. We haven't seen that yet, but I wouldn't be surprised to see Pam Bondi's DOJ bring an action like that. And I believe it theoretically could be enforced by, say, state attorneys general, say, in certain politically red states, to enforce these rights as well, which I wouldn't be surprised to see in the coming months and beyond. And so this is an area of very significant risk for every nonprofit organization. And what we are encouraging our clients to do is to obviously scrutinize any programs that you have like this, and analyze whether or not there are any exclusionary features to it that are in part based on race. And if so, we're not encouraging our clients to abandon these programs. What we're encouraging them to do is to change the eligibility criteria to make them not exclusionary based on race. But you can still make them exclusionary based on other certain characteristics. And we've come up actually we brainstormed, Holly and Kevin and I, a pretty good laundry list of different, what we believe are legally acceptable criteria. Things like perhaps based on a needs-based, income-based criteria, perhaps based on early career individuals, where they are in their career, perhaps based on having the applicants write some form of a short essay in the application that explains how they've overcome adversity or hardship in the past. And there, just like Justice Roberts said in his majority decision in the 2023 U.S. Supreme Court decisions, he said, if colleges and universities, enforce an essay requirement like what I just described, and the applicants talk about how they've overcome overcome hardship and adversity, and talk about the racial discrimination that they've overcome, he said that's okay, because you're not making it exclusionary based on race. You're just bringing that in as a factor to explain how you've overcome hardship and adversity. And that is exactly what most colleges and universities have done since 2023. And it's also what Joe Biden's Small Business Administration and certain other federal agencies did last year, I believe, seeing the writing on the wall from the U.S. Supreme Court's decision. They, for instance, for the Small Business Administration, for decades, there was a program, a low-interest loan program that was only eligible to small businesses that were majority owned by minorities or women. And it was presumed that minorities and women had overcome hardship in the past and therefore were eligible for these preferences and these SBA loans. That's gone. SBA eliminated that, and they've replaced it with a similar type of, essay application type requirement where you have to show how you've overcome hardship and disadvantage in the past. And so that's another model. There are other ways to do this as well, but it's really important that you focus this as a significant risk area. Let me move on now to employment. And this is an area that applies to every association and nonprofit organization, presumably any, except maybe a really small one that doesn't have employees. But any nonprofit that has employees has to really focus on their employment policies and practices to see, are there any policies or practices that in any way arguably engage in this sort of reverse discrimination, right? Do you have preferences in the hiring process? Do you have internal leadership acceleration or promotion type initiatives designed to increase the diversity of the senior management ranks within your organization and help folks that maybe didn't have as much advantage in the education and training part of their careers, to help accelerate them and promote them and lift them up and make your senior management ranks more diverse. Things like that. Do you have any sort of paid fellowship programs? Obviously, that could involve a contract. But here, we're talking about employment practices generally. And this is an area of very significant risk. Remember now, you're going to have the Trump administration that is in charge of the U.S. Department of Labor and the Equal Employment Opportunity Commission. And I fully expect that both of those agencies, if they haven't already, are going to continue to enforce kind of this anti-DEI focus, and especially when it comes to reverse discrimination in the employment setting. And so remember, employment laws can be enforced by the U.S. Department of Labor, certainly by the EEOC. They can be enforced by state departments of labor, and they can be enforced by private plaintiffs, by aggrieved employees who believe they've been, for instance, reverse discriminated against. And all of them, any of them, can bring claims. I expect we're going to see the red state attorneys general bringing many more actions in the future in this regard. I certainly think it's going to embolden many employees to bring these claims. We've already seen it already, including like the Supreme Court case that was heard last week. And so this is something that you really, really want to focus on. It's an area of very significant legal risk. Finally, the last area I want to talk, well, two last areas I want to briefly talk about. One is, well, there's not many on the books right now in the state level. Keep an eye on state laws and state executive orders issued by governors. We've seen some, for instance, in 2022, Florida passed a law that's colloquially called the Stop Woke Act that restricts diversity-related training in private Florida workplaces, including nonprofits based in Florida, and including employees, like remote employees of nonprofits that work from Florida, because most employment laws apply based on where the employee is located, not where the employer is headquartered. Now, that law is currently on hold. It's been enjoined by federal appellate court. We'll have to see how that one plays out. But we do know there are close to at least 30 states right now, primarily red states, that have laws that have been introduced, bills have been introduced in their legislatures that fall into this anti-DEI realm. And keep in mind that states have a lot greater ability to regulate private nonprofit organizations than the federal government does. The federal government only can regulate in certain ways if there's certain federal hooks where federal law can apply, things like federal funding and federal employment laws, and certainly Section 1981, and in a few other areas. But states have a lot more ability to do this, so we're going to have to really keep an eye on this, keep a very close eye on that. And then finally, we've been getting a lot of questions about federal tax exempt status, right? And we know there's a lot of talk on Capitol Hill right now about the tax bill that's going to be taken up later this year in Congress to try to make permanent the 2017 Trump tax cuts, and finding ways to pay for those tax cuts. And there are a lot of proposals floating out around Capitol Hill to, for instance, either gut or eliminate the federal tax exempt status for 501c6 trade and professional associations, to target 501c3 colleges and universities, and especially their endowments, and taxing those to a much greater extent, things like that. But there's also been some concern. We haven't seen any evidence of it yet, but I'm getting a lot of questions about it, so I know it's a concern that some people are afraid that the Trump administration will weaponize the IRS to pursue organizations that it believes do not qualify for tax exempt status, including, for instance, 501c3 status, because they engage in illegal anti-DEI initiatives, particularly ones I think that engage in it as kind of their core mission or purpose. And there is some concern because there is a lot of precedent for saying that the courts have upheld IRS denial or revocation of tax exempt status to organizations that it believe are violating public policy. Things like engaging in, like back in the in the 50s and 60s, the kind of KKK type organizations, denials of tax exempt status there, organizations that are deemed to be funding terrorism, things like that. There's plenty of precedent for saying you can't qualify for tax exempt status if you're significantly engaging in illegal activities, maybe even less than significantly. And there is some concern that the IRS could end up targeting some organizations like that for potential revocation of its tax exempt status. Again, we haven't seen any evidence of it yet, but it is definitely something to keep an eye on. And then finally, this is not another legal area, but something that we are seeing very, very much across the board, and that is the flow down effect and impacts and repercussions of all of this on members, donors, sponsors, funders, grantors, exhibitors, advertisers, attendees at conferences and webinars and things like that. We're seeing it in lots of different areas. For instance, a number of our clients have been asked by potential conference registrants, like by federal workers, asking if there's any DEI content at their conferences, and if so, they're not able to attend. We're seeing some would-be conference participants just boycotting association conferences, either because they still contain DEI tracks and content, or because they've removed them. We're seeing kind of backlash on both sides. With respect to anyone that receives federal funds, and I gave an example earlier, there's so many associations that have members that receive a lot of federal funds. And one of the things that we are seeing as a result of those executive orders relating to federal funding is federal agencies are now asking federal award recipients to certify that none of the funds that they received will be in any way used to fund any anti-DEI initiatives. And some of the requested certifications are even broader than that, and asking if you are a federal award recipient, do you more broadly, regardless of whether you're using the federal funds for this purpose, do you more broadly engage in any illegal DEI activities? And because you're having to certify this under penalty of perjury and under potential criminal liability under the Federal False Claims Act, it's getting a lot of people's attention. And what we are already seeing is the fallout effect on, for instance, associations, with those members saying, oh, I don't think I can attend your conference. I don't think I can renew my membership. I don't think I can be a sponsor because my organization is being asked to make this certification. And see, these are all things that are kind of the flow down effects. And by the way, if you are a sub-recipient, subcontractor, sub-grantee, you are likely going to have to make these same certifications as well. And so this has a really broad potential impact on the entire nonprofit community, and something we're going to really want to keep a close eye on. I'm going to wrap up that portion. Kevin, is there anything else you want to round out that I didn't cover? And then we'll open it up for questions.
No, nothing to add, but I think there are a couple of kind of clarifying points that there are already questions rolling in on these topics. So I think we might just roll into the questions because we will address a bunch of those clarifying points through the questions, if that's all right.
Sure. Sounds good.
So I'm going to tee up the first one for you, Jeff. This is getting back to the Civil Rights Act. It's my understanding that the Civil Rights Act only addresses race, but not sex. Is this correct? And if so, does the federal law supersede state laws that are adding sex in their eligibility along with race, ethnicity, etc.? So talk about the interplay there.
Yeah, I definitely need to clarify. So first off, we're talking about federal civil rights act, where the primary, there's a lot of federal civil rights laws, including like the Americans with Disabilities Act, for instance. But I'm referring to the two primary federal civil rights laws, which is the Civil Rights Act of 1866 and the Civil Rights Act of 1964. I believe I got that. You're right. And those two civil rights acts are very different. The original one, 1866, was much more limited. I'm not really familiar with the full contours of that original Civil Rights Act, but for the purposes of this discussion, I am familiar with it. And that only prohibits discrimination on the basis of race in contracting. And that's limited to race only, but that's only for purposes of that whole Section 1981 bucket of issues that I just talked about. The Federal Civil Rights Act of 1964 contains a lot more categories of protection, including for sex and gender and plenty of other things. And those have been interpreted by the U.S. Supreme Court in recent years to provide additional civil rights protections for members of the LGBTQ plus community and others. And those protections are a lot broader. So with respect to that, state civil rights acts can go further than that. And that is the case in a lot of blue states. There are additional categories of protections that do not exist under federal law. And that's okay. And that's allowable, at least to date, it's been allowable. Like, for instance, in DC, where I live and work, it's illegal to discriminate in employment on the basis of matriculation, like whether or not you have a college degree. That's not a protection that exists under federal law. And so for employers or an employee who's based in DC, they are subject to that protection, but the federal protections provide like a floor, basically, that the states are not allowed to go below, but they can certainly go beyond. So I hope that answers that question.
Jeff, another one for you. This is coming in. We are a 501c6 with a 501c3 foundation that has allowed donors to designate funds for minority scholarships for several programs. They're opening up eligibility of these scholarships to not be exclusionary based on race and ethnicity, but are looking for ideas on the designation of donor gifts that meet the spirit of overcoming hardships that don't raise concerns. I know a lot of things we've talked about with clients with respect to scholarship programs is that they have donor restrictions based on donor agreements that may have been signed years ago. So can you talk a little bit about that?
Yeah, well, Kevin, you know this issue well because we've done a couple analyses for clients on this, including one this week, I think. So this is a really big area. And so what this involves, like many areas of law that we deal with, they involve multiple areas of law, right? And we're trying to weigh, and I'll answer this question in a second, but there was a good example from this morning, an email exchange I had with a client where uh, in a recent DEI analysis that we did for them, we flagged their designated board seats for certain minority groups as an area of concern because we presumed that their board members had to sign some sort of a conflict of interest and confidentiality agreement or agree to terms like that that would be construed as an agreement. And the general counsel wrote back and said, actually, they don't have their board members sign anything like that, which I thought was unusual, certainly not a best practice, and certainly exposes themselves to potential risk in other areas completely unrelated to these DEI initiatives. And we recommended that they start adopting that practice. And he said, well, aren't we going to then create more potential liability risk under Section 1981? And yeah, theoretically, yes, although I think of all the different areas of risk, that's a very, very low area of risk, generally speaking, in the bigger scheme of things. But you always have to counterbalance things. Like we're constantly weighing one legal risk against another, pros and cons of different options. And, you try to thread the needle and come up with a solution that balances them to the best degree possible. But that's important to do that balancing. And it's also important to do that balancing with other non-legal risks. Financial risks, business risks, member relations, public relations, making yourself a bigger target. If you receive federal funds, like you got to balance all of those things in making your decisions. And there's no one size fits all. We just heard back this morning from the CEO of another client that we just gave her a DEI memo yesterday, pretty comprehensive one. And one of the things she said she really appreciated the most was our discussion at the end of the memo about how all of these things have to be balanced. And the balancing is different for every single one of these initiatives. So back here, this example, Kevin, remind me, what was the specific example here?
Let's see. Talking about ways for dealing with existing grant agreements or how to kind of live up to the spirit of grant agreements that may restrict
The
based on
donor
race.
Yeah.
Yeah, donor
So
race. Yeah, donor
the
agreements.
donor restriction issue. So, we've dealt with gift restrictions, gift acceptance policies, gift agreements, forever. And those issues are important because this is all governed by the state version of the Uniform Prudent Management of Institutional Funds Act, which basically says, well, if you have an agreement, it's going to be governed principally by the written gift agreement. If there's no agreement, you still are governed by the gift restrictions that the donor imposed when they gave the gift. Sometimes there are gift agreements, sometimes there's not. You certainly, generally speaking, want to enter into a gift agreement to the extent possible. But if there is a gift agreement, for instance, that says, I am giving you money to only be used for, minority, someone who falls into a minority class, may be more specifically defined by race or whatever, who want to attend college or graduate school to pursue a career in your profession, in that line of profession for the association and or its related foundation. That is a binding restriction, right? Whether or not it's codified in a gift agreement or not, it's a binding restriction. And then we come in, for instance, and do an analysis and tell the organization that because these scholarships are limited in part based on race, that there's significant Section 1981 liability, right? That doesn't void the donor's intent in terms of the gift restriction. Now, you might be able to make some argument that the contract is void as against public policy if it's requiring the organization to do something that's illegal. But the practical reality is that you got to go back to the donor. You need to explain the situation to the donor, and you want to try to convince the donor to modify and broaden the permitted uses of the funds. This is say that we're typically talking about some sort of an endowment or something. Modify and broaden the uses of the fund, or just modify them in a way along the lines of what we just talked about earlier, to not base it just on race, to find some other criteria that still hew to the spirit and intent of the gift, but doing it in a lawful manner.
Yeah, and there are actually a lot of different questions in the Q&A box right now about some of the different categories. So I wanted to just get into that for a second. I think some of those categories that we're seeing that are race neutral that we've seen some clients go with is, for example, restricting scholarships only to students at historically black colleges and universities because those universities accept non-black students. So just by it's not an explicitly race-based criteria. If you're only now, it has the tendency to serve a lot of black students if you're opening it up to students just from HBCUs, but it is not exclusively race-based. It does not exclude anyone based on their race. It might exclude people based on their school, and that's different. Other things that we're seeing, I think somebody asked a question in the chat about, people from countries identified by the World Health Organization. That's a tricky one because it could get into issues of the ethnicity that we want to avoid. But if that designation by the WHO is about, impoverished countries, then that likely falls into a category of a different kind of charitable class. The poor, the disadvantaged in economically disadvantaged in other ways. So that's something that you can consider, but you don't want it just to be a direct proxy for ethnicity because that's not permissible.
Yeah, and Kevin, let me address another question that's a lot in the same vein. And I got this question from a client board of directors yesterday. So we know that Section 1981 and the prohibiting discrimination in contracting on the basis of race is limited to race only. And so for contracts, scholarships, grants, things like that, if you were to limit it to only women, however defined, and that's a big issue, obviously, as many of you, all of you know these days, and an issue with some of our clients are grappling with, but limited to women only or limited to members of the LGBTQ plus community. From a pure Section 1981 liability perspective, and assuming we're only talking about contracts, we're not talking about employment. If it's in the employment space, it's a whole different ballgame because all of these things are then opening yourself up to reverse discrimination liability. If there's like an internal, staff leadership acceleration program or something like that that's limited only to women or only to members of the LGBTQ plus community, that's a problem from a reverse discrimination perspective and employment. Outside the employment area, though, at least the way the law is as of today, we can't point to anything that would say those programs are illegal or run a significant liability risk. However, from a practical perspective, if you're going to eliminate your programs that are limited only to people of certain races, but you're still going to allow some of those other exclusionary type programs that might create some political problems, optic issues, equity issues, things like that. And so some of our clients are struggling with that. And one of the things I've encouraged them to do is to at least consider, even though it's not purely from a legal perspective, move away from any of those more exclusionary, at least based on someone's gender, skin color, sexual orientation, move away from those and find some other criteria that can be applied more equitably across the organization. All right, Kevin, I'm
Right,
trying to
Jeff,
get
and
there a
that's
few
something
more.
we advise broadly. Make your inclusion policies very broad. You can't say, "Oh, we want inclusion, but we're restricting. You're not eligible to apply if you're white." Those are the very specific examples that some of these advocacy organizations are bringing lawsuits over, and ones that organizations need to be very mindful of. There are also some terminology that has been very common for a long time amongst organizations that have DEI goals, and that's underrepresented communities. That's one that I think organizations need to be very careful of because it implies the existence of a quota. Because what are you talking about your representation based on? Is it based on representation in the entire U.S. population? Is it representation in just your membership? We had a client recently who tried to peg committee membership to the racial makeup of its committees to the racial makeup of its membership. And that is almost, to a T, that's a numerical quota based on race. And that's something that should really be avoided. So the underrepresented community type language is well intentioned, but can be problematic if it implies the existence of a numerical and race-based quota.
Yeah, and someone asked, can we use the criteria underserved community? It's the same answer, the same guidance. But just keep in mind, and I see a number of these questions, we get them each webinar we've done, can we do this? Can we do this? Can we not do this? Can we not do this? Is this illegal? Is this legal? And, the one thing to keep in mind is there is no answer to those questions. There's no one answer. It depends. Some of it depends on the details. Some of it depends on the context, right? Is it in the employment side? Is it in contracting? And is that exclusionary criteria based in part on race or some proxy for race? Like, we have to analyze it within the context. And then within that, we can give practical guidance and advice on how you might need to change things. But one thing I would encourage is don't just get caught up on the labeling. The administration is very much, as Kevin, I think, alluded to earlier, has already flagged those issues in some of the executive orders. That being said, we know we have a number of clients who are like scrubbing their website to get rid of any DEI type language or anything that would be a proxy for DEI. And that's not, we're not necessarily promoting that sort of a practice, by the way. I don't know that it could hurt from a purely legal and risk mitigation perspective. But again, you have to balance it against what are our core values? What do we really stand for? And one of the things that we are definitely encouraging our clients to do is to not run away from your core values. If you can find ways to modify some of these programs and initiatives that helps you to mitigate your legal risk, mitigate some other risk, maybe make you less of a target, maybe make the fallout from your members and donors and sponsors and grantors a little bit less, then you should consider that. But don't get away from who you are. All right, Kevin, I have time for maybe 2 more questions.
Yes. Let's see. Some of these we've addressed kind of as a larger group. So, Jeff, can you talk a little bit about kind of leadership development programs, specifically diversity leadership development? And I think this is really trying to get at kind of pipeline programs that intend to develop a diverse class of future leaders of an organization.
Yeah, and so first off, again, distinguish. Maybe I'm talking and think like a lawyer because I am a lawyer, but first thing I always do is, okay, what bucket does this fall in? Are we talking about internal kind of leadership development at the staff level, maybe everything from hiring to internal promotion and development, professional development at the staff level? If it's anything in the employment setting, you're going to have to take a much, much harsher look at those programs because I think in the article that we wrote back in 2023 after the U.S. Supreme Court decision, we wrote that those programs already are probably highly suspect from a legal perspective. And this is well before the second Trump administration came in. But if it's in the member space, more generally, again, if it involves a contract or anything that could broadly be construed as even an implied contract, and if one of the limiting criteria is race, that is going to create potential Section 1981 liability. But if it's not based on race, if whatever the criteria are defined in a way that does not limit your eligibility just based on skin color, then I think that's a lot less risky. Again, something you still want to consider and take into account in your overall risk mitigation analysis, but something that we would not point to as having a high degree of legal risk.
And I think that just about brings us to our time. So I want to turn it back over to our gracious host to wrap us up.
Excellent. Thank you, Kevin, and thank you, Jeff, very much. We appreciate your your involvement here, and it was a great session. I know that there were probably some questions that that you all weren't able to get to, and just to put forward to those folks that they're welcome to reach out to you all directly. Here's that contact information. We'll follow up after the session with a copy of the slides and a recording of the session. So look out for that. Look out also for other upcoming events. On March 20th, we're going to be joined by the Mental Health Coalition to talk about how nonprofit executives can support employee well-being. And on March 25th, we're going to be doing a session on how to have difficult financial and budget discussions with your board. So look out for those 2 sessions as well. But we will wrap it up here. Thank you all very much again for attending. Hope it was worthwhile. I think it was worthwhile. It certainly was for me. Kevin, Jeff, thank you both again very much. And hope everybody has a great rest of your day. Take care. Thanks again.
Thank you.